S12Q 1648, James R. Holland II et al. Versus Stephen N. Cavanis. Joe Kingma for Appellant, Brian Smith, Frank Beltran for Appellee.
May proceed when ready.
May it please the court. I'm Joe Kingma with Carlock Copeland. With me are John Bunyan and Pete Werdesheim, and we represent Jamie Holland and his former law firm, Wettermark, Holland, and Keith. The question before the court today is certified from the Southern District, and it is it proper for a jury to consider a defendant's worldly circumstances when deciding the amount of damages that should be imposed under O.C.G.A. 51-12-6?
Kingma, let me ask you, I know we all taught basic tort law in law school, but I assume most of, and I know Mr. Belton will ask you, most of theirs, I guess, will be a statute was changed or something, and you will, I know, address that, but it seems to me that's going to be the crux of our decision here. What was the effect of that?
Justice Hines, I think that's exactly right, because the statute was changed under tort reform in 1987, and I think the question before the court is what was the effect of those changes? In order to try and highlight that, put on the screen, on the left side we have the statute before the 1987 tort reform changes, and on the right side we have the statute after the 1987 tort changes. And I think, as the court can see, these were dramatic changes, and we submit that they were important changes, and they were changes that were made for a reason. Perhaps the best way to frame these changes is to consider the Brunswick gas case, which was cited in both our brief and in my opponent's brief as well. Brunswick Gas and Fuel was decided the year before the legislature enacted these changes, and Brunswick cried out for these changes. The concurrence, a two-judge concurrence in Brunswick, said that 51-12-6, the statute we're here about today, is a badly written statute of uncertain origin. It said it was substantially undefined under Georgia law, under the Georgia case law, and it noted that provisions allowing consideration of the party's worldly circumstances were the worst problem in the statute. Brunswick Gas in 1986 said those were the problems with 51-12-6. And we submit that the legislature heard that criticism and they responded. As the court can see, the original version, the pre-tort reform version, specifically said that the worldly circumstances of the parties can be considered by the jury in a case that falls within the provisions of 51-12-6. The post-tort reform version of the statute removed that language. We submit, and we've cited cases that suggest when the legislature makes a change like that, we have to assume that there was a reason for the change.
But Mr. Kingma, the Tort Reform Act of 1987 also struck the language from 51-12-6 that said that the jury could consider the amount of bad faith in the transaction and all the attendant circumstances. You don't contend that the legislature intended to remove those factors from the consideration of the jury, do you?
Certainly not, Justice Blackwell. And as the court's aware, you're always entitled in a tort case, and I've got some appellate law with my name on it. I was on the losing side that says that. So, for example, if it's a breach of fiduciary duty case, such as this case, Did this change to 51-12-6 remove the plaintiff's ability to prove the breach of fiduciary duty? Of course not. What the change in the statute did is it took away the vindictive caption, which was the caption of the statute, and it took away the provision of worldly circumstances. I guess what I'd submit is, as the court in Brunswick Gas said, this was a poorly drafted statute. It was a little hard to tell exactly what it did and what it didn't do. And the changes that they made clearly removed the worldly circumstances from the jury's consideration under 51-12-6 in our view.
Is the only place that you could bring in evidence of worldly circumstances under that portion of the prior statute?
Yes, Judge, it's interesting, as I was going to get to in a minute. I'm sorry, Justice Namias,
right.
A little slow this morning. 51-12-5 was the pre-tort reform version of punitive damages. And strangely, 51-12-5 didn't allow you to get into worldly circumstances. This statute, 51-12-6, as far as we can tell, was the only statute that allowed the jury to see evidence of worldly circumstances. What the legislature did with the 1987 changes is they flipped that in response in part to the criticism in the Brunswick Gas case. And they said, if there are damages, and I'll go ahead and put that up now. 51-12-5 was the pre-tort reform punitive damage statute, and that's on the left side of the screen. 51-12-5.1 superseded 51-12.5. And so the legislature set forth punitive damage statute and made it abundantly clear how we would deal with punitive damages. And as a result of that, this court has seen numerous cases, as have all the lawyers here, where 51-12-5 comes into play. And 51-12-5.1 specifically says that if the jury checks the box, if the jury finds that punitive damages are appropriate, then under D2, which is highlighted on the screen, then the jury gets to hear such evidence as is relevant to a decision regarding what of damages will be sufficient to deter, penalize, or punish the defendant in light of the circumstances of the case. So we know the 1987 legislature knew exactly how to get worldly circumstances before the jury because they did it in 5.1. And in all the cases of punitive damages cases, post-1987 law, that's exactly the way the trial courts have done it, and that's exactly the way the appellate courts have handled it. You get to prove that you're entitled to punitive damages in the first phase, which is the way the statute sets it forth. And then in the second phase, you roll out the worldly circumstances. They knew how to do it because they did it in 5.1. But we'd submit that they clearly knew when they didn't want to do it because they took the language out of 51-12-6, which is the highlighted language on the left. They specifically took that language out, and then they specifically also said you don't get punitive damages under 5.1. So under our reading, the statute is clear. Now, what has muddied the water somewhat has been the Tahampton case, which was decided in 1992. Tahampton was the kind of case that can make bad law. It was a pro se ex-husband who sued his ex-wife, and according to what we read in the case law, had been battering her and taking her stuff. And so then, being the kind of guy he was, I guess, he sued his ex-wife after having battered her and taken her stuff post-divorce. He was pro se. The ex-wife counterclaimed for several things. She said he stole some carpets. She said he battered her. She said he damaged her feelings under 51-12-6. And the decision in Tahampton, 1992, was frankly the decision that we'd ask this court to overturn. Numerous problems with it, but the easiest one to understand is this. Tahampton specifically quoted and cited 51-12-5. 51-12-5 doesn't apply to post-tort reform cases. However, the decision also specifically cited 51-12-6, the language that's the statutory change, the post-tort reform language. So it cited both one statute that only applied before 1987, and one statute that only applied after 1987. That clearly can't be. It never mentions 5112.5.1, which was the governing punitive damage statute after the 1987 changes. And it didn't require an election of damages as the new version of 5112.6 did. We would submit that the Thompson case, perhaps because it was a pro se case coming up, and perhaps because it was such a recent change, is just fundamentally wrong. We think that this court should respond to the Southern District's question by looking at the statute and the statutory changes. And I think the Stepperson case, which we've cited, also points out clearly what this problem is. And we'd ask that the court answer the certified question, no. I'd like to reserve the rest of my time. Thank you.
You may. Yes, sir.
May it please the court. The key point that we want to make today is that the legislature never intended to do what the defendants urge upon the court today. If you look at the history of this statute and you look at what they did in 1987 with the tort code as a whole, there is no indication that they were trying to change the law that had always applied, that allowed you to consider the defendant's worldly circumstances when awarding damages under this fairly obscure code section. It's important, first of all, to realize that 5112.6 is not a code section that comes into play anytime someone gets their feelings hurt. The case law going back, I think, over 100 years says that this tort damages code section only comes into play when you have willful, wanton, and malicious conduct. And the jury in this case found that. This is a case where a lawyer missed a statute of limitations and then, frankly, lied to his client about it after the fact. And then after he received a letter from our co-counsel, Durham and Crane, telling him that our client may have a claim against him for his legal malpractice, he then deleted some evidence. He went into his computer system and deleted a to-do reminder that his secretary had left for him, telling him that he had a deadline coming up. He then missed the deadline, blamed his secretary, and deleted the computer record showing that his secretary had entered that deadline correctly. In their briefs, they argue that somehow this didn't matter and that this wasn't a very bad thing to do because he had already informed his client that he'd missed the deadline by the time he did that. I don't know if that makes it better or not. But the jury found, in response to jury interrogatory number 3, that his conduct was willful, wanton, or malicious. And those are the kind of cases that we're talking about here today. Now, the code section that we're dealing with, 5112.6, is about as old as it can be. It goes back to the original Georgia Code of 1863. If you pull the original TRR Cobb Code, the code section in that original codification of it is exactly the same as the code section was in the Westview case in the 70s, which is a decision of this court, which is probably the main decision on 5112.6. There were some changes to the code section in 1987, but the 1987 Tort Reform Act began as a House bill. It later went over and the Senate drafted a different bill. The House and the Senate couldn't agree, and then they drafted a conference committee came up with a consolidated bill that had some different things in it, but was an attempt to reconcile their differences. but neither original draft of the way that they were changing the tort damages code made any change to the part of 51-12-6 dealing with the worldly circumstances. Now,
So what? The final law took it out.
well, I think
Do
it
you
goes...
know why? Do you know why the original drafts said what they said, or why they have been changed? You have a
unfortunately,
poll you have the poll of the legislators, or have you interviewed or deposed any of the legislators to find out what was going on with the original drafts?
we have not, and I don't think that'd be admissible even if we did.
Right. So the only thing we're considering is what they actually voted on and the governor actually signed into law, right?
That's correct.
And that took out this language.
It took out this language, and it also took out the entire list of evidentiary factors that the previous code section had instructed juries to consider. And, you know, as Justice Blackwell hit upon in Mr. Kingma's argument, you know, the list of factors was the worldly circumstances of the parties, the bad faith in the transaction, and all attendant facts. And I have a markup of the changes to the statute.
Could I ask you this too, Mr. Smith, while you're doing that? 51-12-6 kind of specifically states that punitives under 51-12-5 or 5.1 are not awarded, does it?
It does.
Okay, now, and so hone in on that for me, and how do you deal with that, if you would?
Well, that part of that statute is essentially a codification of what this court had decided in the Westview Cemetery case in 1975. The Westview Cemetery case dealt with a case involving a body that had been disinterred without the family's permission and moved to a different part of the cemetery, involved mental damages where there were no special damages. And in that case, the plaintiff recovered or sought to recover at trial under both the previous punitive damages section, which was codified differently at the time, but became 51-12-5, and also what became 51-12-6. And the way I think of the Westview case is it codified the no double dipping rule. What Westview said was that these two code sections, punitive damages and 51-12-6 damages, are analogous in several ways, and it gave a list of several ways in which those two statutes are analogous. One applies where you also have other damages. One applies where you have willful and wanton conduct leading only to mental distress damages. And the Westview case basically said you don't get both of them because they're partially the same thing. They're very similar and they're analogous in several ways. So what the legislature did with that part of the statute is they codified the rule in Westview that if you get 51-12-6 damages, you don't get 51-12-5.1 damages because you can only proceed under one of those statutes or the other.
What are worldly circumstance evidence, which is basically wealth?
Yes.
What is the relevance of a defendant's wealth to anything other than punitive damages, damages designed to punish and be punitive?
Well, the cases on 51-12-6 favor deter. There are some cases, and there's...
Most of them actually call them retributive.
Yes.
Or
yeah.
vindictive.
Vindictive is
both of which are traditional punitive damages. And in fact, Westview, the case you were just talking about, is very strong on that point, that it is it's a form of punitive damages.
Yes, it is in part punitive. That's what Westview said, and that's what the post-1987 case of Ralston versus Dahlonega said, where the plaintiff in that case recovered against the municipality of Dahlonega. It was actually an arbitrator's award. It was appealed under the standard of manifest disregard of the law. But when it came up to the Court of Appeals looked at it and said, because Dahlonaga's argument was this is a punitive damages statute, so you can't recover that against the municipality.
Right. But in the rest of our tort law, you get compensatory damages. You get the damages to compensate for your tort.
Yes.
Right? And in fact, you can't usually, in fact, I think anywhere else, you can't submit evidence of the defendant's wealth because it is deemed prejudicial and has nothing to do with your harm. What the defendant doesn't affect how you were hurt. So this was the only place, as far as I know, in Georgia law that you could get worldly circumstance evidence. And what I'm trying to figure out is if it's clear that you can't get punitive damages anymore because it says punitive damages are only under 5112.5.1, then what relevance does worldly circumstances have?
Well, the Ralston case says that 5112.6 damages continue to be in part punitive. They are not punitive damages such as would bar them from being recovered against municipality, but that has always been the purpose of 5112.6 damages, has always been to deter the wrongdoer. And to deter this wrongdoer, you need to find out what would be sufficient to deter him.
And is Ralston our court's case?
No, it's a Court of Appeals case.
Right. So it says that 5112.6 is still a deterrence statute.
Yes. It says that 5112.6 remains in part punitive and deterrent.
Even though 5112.6 now says expressly that you can't get punitive damages under this statute.
Well, what it says is that you cannot get punitive damages under other statutes that are similar to it so that you don't get a double recovery. That is what the Westview case says, is that these other similar statutes award the same thing, and therefore you have to proceed under one or the other. And this is the current language of 5112.6 says exactly that. It doesn't say this is no longer a punitive damages statute. It doesn't say damages under this statute are not for the purpose of punishment or deterrence. It says if you recover damages under this statute, you cannot also recover under 5 or 5.1.
And what was the effect of taking out that list of circumstances?
The
what
effect,
did it do?
Well, I think the purpose of it was
Not the purpose. What is the? I don't know how you determine the purpose. What was the effect of taking out that language? How did the law change?
It didn't.
So the legislature went to the trouble of changing the words in a statute, and yet it didn't change the law an iota.
It makes sense when you look at the damages section of the tort code as a whole. They enacted 5112.5.1, which also does not have a list of evidentiary factors. And lists of evidentiary factors are not something you usually put in a code section dealing with tort damages. You know, most of the damages code just says what damages you get. It doesn't say what evidence is to be considered.
Right. You have a background rule of law, which for tort is compensatory damages. You have a statute that creates a very unusual exception to that. For a particular tort, you can have consideration of wealth. The legislature takes that out. It would seem like by taking it out, you revert back to the background law. And you're saying they take it out, and even though they took it out, it continues to have this very unusual rule in effect.
Yes, because I think that the key phrase in the code section is the enlightened conscience of impartial jurors. That is not a phrase of limitation. That is a phrase empowering the jurors to award damages such as they see fit in these types of narrow cases under this specific code section. And if the legislature had wanted to turn 5112.6 into a nominal damages statute, which is essentially what the defendants are arguing, they would have said so. That's what 5112.4 says, which deals with damages generally.
Why is it nominal? I mean, you could put on evidence of my understanding is it's hurt feelings. You put on evidence of your pain and suffering, your mental pain and suffering. That's what you have to do to prove that you actually had damages, right? And then you let the jury in their enlightened conscience, like we do with other pain and suffering, put a value on it.
Under this code section, under all the law, including the Westview Cemetery case, which other cases after this law was enacted have echoed, it has always been a dual purpose to this statute to both compensate the plaintiff for his mental damages and to deter the defendant from committing this kind of willful, wanton, and malicious conduct. And the McClendon case talks about awarding money that would be, in the terms of that case, smart money, money that would be sufficient to compensate the plaintiff and also to deter the defendant from committing this kind of conduct. And if you take out the worldly circumstances, you're not able to do that anymore. There's over a century of case law showing that the intent of this statute has always been both to compensate and deter. And the worldly circumstances are relevant to enlightening the conscience as to how to do that, just as the bad faith is. You cannot take out bad faith from consideration because you have to have bad faith before you can be proceeding under this code section. And certainly you can't take out attendant facts. And what the defendants are arguing you should do is take a deletion of a list of evidentiary factors, which usually aren't included in this kind of code section, and say X and Z still apply, but Y does not.
But if you take out the unusual factor, what is the background law in the tort code on considering attendant circumstances? I think juries can consider attendant circumstances in every tort case. And what is the law on bad faith? In claims that you have to show bad faith to prove the claim, you get to show bad faith. So I don't think your argument follows that if you take out 3 factors, 2 of which apply in every tort and 1 of which is exceptional, the legislature was showing it was eliminating the 2 everyday ones.
Well, this is not a damages code. I mean, this is not a negligent section of the damages code. This only applies under intentional torts, and both the House and Senate original drafts of their changes to 5 before they came up with 5.1 made exceptions for intentional torts. This is not something that's normal. And under the case law over a century, with this statute applying the first sentence, where the entire injury is to the peace, happiness, and feelings of the plaintiff, and you have the other factors that the case law says you have to have before you can proceed under this code section, meaning willful, wanton, or malicious conduct, then the measure of damages is solely what the jurors in their enlightened conscience determine it should be, and you have a century of case law saying that the purpose of that has always been and continues to be that you should both compensate the plaintiff and deter defendants from committing this kind of intentional misconduct. And
Counsel, what did the common law say about these kinds of damages, whether they could be awarded at all, the purposes of such damages, and what could be considered prior to the original codification back during the war between the states?
Well, it's difficult to say. There isn't. I mean, I can't find too many pre-1863 cases. There is some language in Westview that says something to the effect that that there is some disfavoring of these kinds of damages generally under the common law. But as far as I can tell, the original code section is essentially a codification of the common law. When the Cobb Code was put together, they didn't come up with new laws. It wasn't something that the legislature put together. It was T.R.R. Cobb's understanding of what the law was at the time. So he was taking something that was the way the law was at the time that he put that together and putting it in a code format. And if you look at that code section, it's exactly the same in 1863 as it was in 1975 when the Westview case came out. And if you look at the markup of what was changed, this is a markup of what changed between Westview and 1987. You'll see that the first sentence has been redrafted in some ways to make some cosmetic changes. I think that was something the legislature did over time to to just bring it up to date, make it less archaic. You know, I couldn't read any meaning into the way they changed that first sentence, changing it from in some torts, and then having that semicolon at the end of that first clause, and then changing it to in a tort action in which, and changing that language. There's no meaningful change there. It's just the legislature trying to bring it up to date and make it fit with the rest of the damages code. And this has always been the law. There is no precedent for the position that the defendants urge upon this court. The only decision from this court that they really rely upon is Moody versus Dykes, in which it really doesn't say anything of substance.
Both of you cite Moody, though, I think. Didn't you cite Moody, too?
I cited Moody to distinguish their citing of Moody.
Well, Moody says this is the law change. We don't have to deal with it in this case. And
Moody,
you say 100 years of precedent. The problem with that is 100 years of precedent interpreting a statute that got changed. So you got to explain why that precedent continues. And your answer is they changed the statute, but they didn't have that statutory change had no effect whatsoever.
What Moody says is the legislature deleted the list of factors, and then it says the plaintiff waived the issue at the lower court, so it's not before us to hear. And I don't see any value in that analysis. It points out what's obvious is that there was a list of evidentiary factors, and now there's not.
Yeah, you're saying Moody really isn't that relevant to this decision.
Exactly, yes.
I can kind of see that.
And the only case on point that really decides this issue is Time.
Thank you, sir. Mr. Kingma, any rebuttal?
Very briefly. Counsel has raised the facts of this case, and I think the facts of this case demonstrate how explosive it is to allow a jury to hear about worldly circumstances before they rule on liability. And the facts are pretty quick, and I've got them on the timeline here. Jamie Holland got hired on October 22nd. On November 16th, a little less than a month later, he filed a lawsuit. He filed it one day late. And as the court is aware, that happens to lawyers a lot somehow. They file lawsuits late. Less than a month later, the answer was filed to the railroad, which pointed out the statute of limitations problem. That was on the 7th of December. 14 days later, Mr. Holland, who lived in another state, and Mr. Cavanis, who was a railroad engineer and traveled from state to state, met. And Jamie Holland told him, and this is undisputed, I missed the statute of limitations, I messed up, you need to hire another lawyer. And Mr. Cavanis did that. Within 10 days, he'd hired new counsel to represent him. So very quickly, less than a month, he discovered he made his mistake. He went to his client and told him he made a mistake and said, go talk to another lawyer, you may need to sue me. Now, after that conversation, after this other lawyer was hired, Mr. Holland deleted a to-do entry in his time matters. What did that have to do with anything? I don't know, but his mistake was clear on the public record because the lawsuit was filed late, and what was in his time matters wasn't going to save him from the mistake he'd made. And he knew that, and he confessed it to his client. Now, having heard that evidence, the jury also heard trial testimony from Mr. Cavanis on his emotional distress. And what he cited, and this isn't everything that he said, but this is the strongest point he had. I had some sleepless nights. And he said his sleepless nights were caused by the fact that he lost his case. Now, under the rule of this case, he lost his case because his case wasn't any good. They couldn't prove he had a case that was worthwhile. So he didn't recover on his underlying case because there weren't facts there to support it. And his damages are, I would contend, nothing based upon what they say is the breach of fiduciary duty, which was the deletion of this entry. But having heard those facts, knowing that all he gets under our theory is general damages, they throw the atom bomb, and the last thing the jury hears is he's got a BMW, he's got a Lexus, he's got 2 houses, he made $1 million last year. And having heard that, they decided he breached his fiduciary duty and hit him with a $700,000 verdict with no damages. And this is a lawyer who made a mistake, missed the statute of limitations, and very quickly went and told his client to hire another lawyer.
My understanding of the underlying case is that his complaint was he would have gotten a settlement of $130,000.
He tried to make that argument along with several others, and I believe that the judge decided on directed verdict that argument did not prevail.
But that's what his claim value of the underlying case was?
That's one of the values that he tried to claim, is that he could have settled the case for some amount of money if only it had been timely filed.
And he recovered $700,000 for his hurt feelings about the $130,000 case.
That is correct.
Mr. Kingma, do you agree with the idea that when a code section sets out specific criteria, specific facts that are to be considered by a jury, and then the legislature goes in and removes those specific criteria, that we then revert to background principles of tort law?
Justice Blackwell, I agree with that 1,000%, and I think you've grasped the hub of our argument.
Well, if we're going to revert to background principles of tort law with respect to this kind of damages, have you taken any look at what the common law said, whether as common law as evidenced by decisions of Georgia courts or the common law as evidenced by decisions of courts in our sister states, what the common law said about these kinds of damages prior to the original codification? Because the problem with relying on Georgia cases subsequent to the codification is they're relying on the codification itself. So it seems to me to move to background principles of tort law, you've got to look back at the pre-codification common law, either in England or in Georgia or in the laws of our sister states. Can you comment on that?
Yes, Justice Blackwell. I believe this court in Westview touched on that briefly and pointed out that you didn't get this evidence in, and I don't think that the plaintiffs have cited a single case prior to 1987 that got in worldly circumstances except under 51-12-6. This is explosive testimony, and it didn't happen in Georgia to my knowledge, and I think a review of the cases will show that. It wasn't even considered to speak of because everyone knew what the results were. So prior to 1987, the only time you got worldly circumstances in was under 51-12-6.
So where might Cobb have gotten this principle from, if not from the common law?
In the original version of 51-12-6, Judge, as I see it, this was a statute that was created for people who had hurt feelings but didn't have any other damages. And Cobb decided from somewhere that we're going to allow these folks to get something, perhaps in part to encourage litigation, frankly, so that, and I think there's some language in some of the cases that say, even though they don't get any money, the wrongdoer will be hauled before the court and will have his wrongdoing pointed out to him. And so I think that's the theory that arose that resulted in 51-12-6. But I must confess, I can't tell you a single case, whether in England or this country, that gave him the thought to create this statute.
But if you view this as a vindictive or punitive damages statute, then at common law or under our current statutes, it wouldn't be exceptional to allow proof of the defendant's wealth.
If it fell within 51-12-5.1, it would be absolutely appropriate to consider consider evidence about the wealth. The statute as revised.
I understand that, but just more generally, in terms of general tort law and common law, you can get defendant's wealth evidence in cases of vindictive torts, punitive torts.
And Justice Namias, I'm unaware of any circumstance prior to 1987 where you could get it other than 51-12-6. And I'm unaware of any circumstances after 1987 where you can get it other than 5.1. I think it has been codified that it is not what you get other than there's a specific provision, and the changes to 51-12-6, I think, point that out. I would like to add that if you look at the legislative history, as I think all of us would agree, you just can't tell. There's not legislative history here which tells us what the legislators were thinking. However, if you read through the legislative history, we had current Governor Deal, former Governor Barnes were both involved in this statute. I'd like to think those two gentlemen knew how to get worldly circumstances before the jury if they wanted to. They could have done it at least two different ways. One way they could have done it is in 5112.6, they could have said you get punitive damages under 5112.5.1. The other way they could have done it is they could have left in the worldly circumstances of the parties language, which was in the statute already. They could have just carved out a little less of the statute than they did. And under our view, there's no reasonable reading of what they did other than to say they took it out. They took out worldly circumstances. They did it for a reason, because if you hurt somebody and you have aggravating circumstances, then you get your damages and you get punitive damages. If, on the other hand, you don't hurt somebody, but you have aggravating circumstances, then you can recover these general damages which are left to the enlightened conscience of the jury. And it says no measure can be prescribed except the enlightened conscience of the jury. And what they'd like to do here is they'd like to create a measure. They'd like to count up your Lexus and your BMW and your house and your other house. But the legislature said no to that. In conclusion, I'd just like to say the law is unclear as a result of automaton, and it's not surprising that the Superior Court clerks have trouble getting the charge right given the decision in automaton. I don't think it is reasonable to assume that the legislature wanted to open up the floodgates for punitive damages and worldly circumstances brought in before they'd be brought in under 5.1. The Southern District, as well as the lower courts in this state, need direction from this court. We respectfully ask that the question be answered no. Thank you.
Our thanks to both sides for your arguments and perspective.